Next, I want to invite Judge DeWeese to speak to us about ethical considerations.
All right, good afternoon. We're in the home stretch. So I will attempt to enthrall you with my talk about ethics for the next close to an hour or so, just so you can all get your credit. The first part of my presentation is going to start off with mostly, I think, issues that are relevant mainly to attorneys who represent individuals who may suffer from mental disease, defect, or disorder. And then towards the end of the presentation, I'll talk a little bit more broadly about maybe some ethical considerations for judges, prosecutors, and everybody else involved. But that having been said, I think it is going to be hopefully helpful for non-lawyers to understand what the ethical obligations are of lawyers who represent individuals in mental health cases. Because, for example, you heard Dr. Brenda Bauer-Smith say that, well, while they encourage their examiners to reach out to defense counsel to get information about why a 704 exam is being requested, they don't always do it. Sometimes there's no time, but sometimes the responses from defense counsel are not helpful. And I think once you see some of the ethical considerations that as a defense attorney you have to navigate, that may explain why others find that the responses from defense counsel are not necessarily always helpful. So with that, the specific rules I'm going to talk about under the Hawaii Rules of Professional Conduct are 1.1 competence, 1.6 confidentiality, 1.14 client under a disability, 1.4 communication, and 1.2 scope of representation and allocation of authority between client and lawyer. And I think these are sort of the main rules that I felt applied in the context of 704 proceedings. So the first rule, 1.1 competence, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Now, this is interesting. I think if you come away with nothing at all today, I think at least you come away with the idea and the understanding that representing individuals in mental health proceedings requires a specialized type of knowledge and a lot of hands-on work. And I would submit that the competence of an attorney in a mental health proceeding, a Chapter 704 proceeding, is a specific type of competence over and above a competence that just requires legal knowledge. And when we get down the road in my presentation, I'll show you the ABA standards, which actually refer to a lawyer having to take a multidisciplinary approach to the representation of somebody in a mental health case. And so that implies that mere knowledge of the law might not be sufficient in order to be competent to represent somebody in a Chapter 704 proceeding. Obviously, the ABA standards don't govern. This is the standard that governs us. But, I think that if nothing else, we have come to understand that competence in this type of a context is something very special. Because as we all know, in a regular case, you represent somebody, they get convicted, or they plead, or they're acquitted, case is done, no further obligation, usually you're done. And in a 704 proceeding, you have an ongoing obligation to really keep a hands-on approach to your client. We talked about having review hearings and making sure they don't fall through the cracks, making sure the hospital does a discharge plan, making sure that this individual actually gets the benefit of the sentence, essentially, the CR sentence that they received. And so I think you do have to know more than just the law. You have to really have a deep understanding of what can affect somebody's mental health and be able to work in that realm. So the next rule is 1.6 confidentiality of information. And this is sort of what I was alluding to when I talked about the comment that Dr. Brenda Bauer-Smith made. So a lawyer shall not reveal confidential information relating to the representation of a client unless the client consents after consultation. The disclosure is impliedly authorized in order to carry out the representation, or as stated in paragraph B or C. And paragraph B says that a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary to establish a defense to a criminal charge. So that implies that, you can reveal confidential information to the extent the lawyer believes reasonably necessary to establish a defense. So this would be the lack of penal responsibility situation, that if your client says, I don't want you to disclose anything, your professional conduct rules do allow you some discretion there to make decisions to disclose certain things. And so I guess this says to establish a defense to a criminal charge, and then, okay. So this talks about PR. And so I guess the question I have then is, I think we'll get to that later, is fitness included here? Because fitness is not necessarily defense to a criminal charge, right? And so what do you do if you feel like your client is unfit, and your client doesn't think they're unfit, which happens often? And then can you disclose? So we'll get to that in a little bit. But again, what I think what we hear sometimes is that from forensics, from probation officers, from AMHD, we want to know the basis. Why are you moving for this exam? Why this? Why that? And I think that the ethical rules shed some light on why sometimes we're not able to, as defense attorneys, you're not able to disclose certain information. And then I guess the question is, if you do believe that it is appropriate and permitted under the rules to disclose certain information, how do you disclose it? And so one of the things I think you have to think about is, do you do it on the record in open courts? Do you file something under seal? Do you file something in camera? Do you have a conference with the judge off the record? And then when you go on the record, it's kind of wink, wink, nudge, nudge. My client, I'm having some difficulties with my client, right? I mean, there's different ways to play that, but I think that's something as an attorney for these individuals, you have to understand and know how to navigate. Okay, and then finally, and I'll get to this down the road in my presentation too, if you take a close look at HRS section 704-407.5, and I'll show you that in a moment, it doesn't necessarily require disclosure per se. I think it says if the defense files a notice to rely on the defense of lack of penal responsibility, or there is reason to doubt, or to believe that mental illness is an issue in the case. And so I don't really know the answer to it, but when I took a closer look at that statute, and I'll show it to you in a moment, my question is, do you really need to disclose anything as defense counsel? So I don't know. I'm just raising questions. So next rule is client under a disability. And so this would clearly be a rule that's applicable to individuals who may be suffering from lack of fitness or lack of capacity. And so 1.14a, when a client's ability to make adequately considered decisions in connection with a representation is diminished, whether because of minority, which is what Corey just talked about, mental impairment, which is our 704 folks, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. And so, that means you have to treat this person not like they're just clueless or like they're not in the room with you when you talk about them. I mean, you're supposed to maintain a normal client-lawyer relationship with that individual. When the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm, unless action is taken, and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action. So here we start getting into the section that I think applies to situations when you have a client who you believe is unfit to proceed, but who says, I'm not crazy. I understand everything. The CIA has told me everything I need to know, right? So that's this situation. And 1.14 continued subsection C says that when taking protective action pursuant to that previous paragraph, the lawyer is impliedly authorized under Rule 1.6 to reveal information about the client, but again, only to the extent reasonably necessary to protect the client's interest. So I think this is what covers the situation if you have an unfit client who is essentially not giving you consent to reveal information. This rule allows you to reveal information that otherwise might be confidential that the client is objecting to you revealing, maybe regarding their mental health status, regarding their diagnoses, regarding their behavior, regarding things that they may have said to you that give you reason to doubt their fitness. And so I think this is the rule that protects you as an attorney in that situation, despite those things moving for a fitness examination. Okay. Rule 1.2, scope of representation and allocation of authority between client and lawyer. And so this again sort of talks about the lawyer's position. You know, fitness is one thing. Fitness is something that the attorney can decide to raise on their own. They don't need the client's consent, and even without the client's consent, you can make certain disclosures of information that otherwise might be confidential in order to basically protect the client. Rule 1.2a says a lawyer shall abide by a client's decisions concerning the objectives of the representation, and as required by Rule 1.4, shall consult with the client as to the means by which the objectives are to be pursued. And so this is the situation when you have a client who potentially has a 704 defense based on maybe the reports that you've gotten back, but says, I don't want to be on CR. I don't want to run a 704 defense. I don't want to run a lack of penal responsibility defense. You know, I want to like do self-defense or reasonable doubt or whatever it may be. And I think going back to the whole competence thing, you need to, as an attorney, be able to understand and be able to explain to your client the pros and cons of a defense, and then allow the client to make that decision, right? Because the issue of penal responsibility as a defense, if you are successful, it's not like winning at trial and getting a straight out acquittal, right? I mean, the person remains on status with the court sometimes for an undetermined period of time. And so you have to be able to explain the pros and cons, and then your client gets to decide whether they want to run a penal responsibility defense. And it was interesting because just anecdotally, I had a hearing the other day in my court, and it was on fitness, and all the doctors disagreed on fitness to some degree. They all agreed, though, that there was no penal responsibility. And I had a doctor testifying, and I think one of the attorneys asked the doctor, you know, about whether they believed that the defendant was able to make decisions about jury trial or no jury trial, or what type of a defense to run. And the examiner, the doctor, was perplexed about that. The doctor was like, well, but he has no PR. Why would he have a trial? Why would he decide jury trial or bench trial? And it was very interesting for me to see that, because it made me realize that we're all sort of in our own little lanes and in our own little compartments, and we don't really have a good understanding always of what happens outside our little designated lanes. And so I think that's another reason why this type of a CLE is a good thing to come to. And while I'm preaching ethics right now, I know I'm preaching to the choir, because those people who do it right are all here in this room today, and those people who don't do it right are not here today. And so to some extent, like I said, I'm preaching to the choir. But again, I think it's you know, somebody can have a penal responsibility defense and decide not to run with it, and that is perfectly okay. And as an attorney, I think you have to respect that. Okay. Rule 1.4, communication. So a lawyer shall reasonably consult with the client about the means by which the client's objectives are to be accomplished, and a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Again, I think, when it comes to talking to your client about penal responsibility, to what the objectives of the representation are, whether fitness is potentially an issue, it's tough because you're dealing with a oftentimes difficult group of the population, but your ethical rules still require you to consult with that individual and not simply make decisions for that person without consulting just because you think you know best. And you have to actually explain the matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So again, it's your client as a defense attorney who gets to make the decision about what gets disclosed sometimes. What defense are we going to run? Do I want to consider a penal responsibility defense in my case, or do I want to just go to trial on the straight up other facts of the case? Do I want to have a jury trial? Do I want to do a bench trial? Do I want to do a stipulated facts trial? These are all things that really need to be decided between the lawyer and the client, and the lawyer is required to reasonably communicate about these objectives. And so this can take a while, and you have to be willing to sit with your client and actually make an effort. I don't know if Nicole's here. Oh yeah. All right. So Nicole in the back there told me yesterday that she had tried to sit with a certain individual and had even, I thought this was great. She'd made flashcards and she had tried to explain a plea form to this person, and what's testimony and what's a motion and what's an appeal. And she'd actually gone through the effort of making flashcards to try to help this individual understand. And after many hours, like 2 hours, the individual still really could not understand. And so, but I thought that's great. That's a perfect example of Rule 1.4B, Miss Hazlett. Good job back there. So anyway, yeah. But so, like I'm saying, I mean, it requires you to really sit with your client. And at the end of the day, we decided that there were probably some fitness concerns. So. And again, it's interesting just to sort of digress a little bit. When we talked earlier today about what do the examiners look at when they decide if somebody fit or not fit, what does the judge do? What does your lawyer do, et cetera, et cetera. One of the things that we talked about in that particular case, and that I suggested, frankly, is why don't you send the examiners a copy of our plea form? Because I don't know if they've ever even seen a circuit court plea form, and have them try to explain that to a defendant and see if they can get the defendant to understand it. Because as Dr. Brenda Bauer-Smith, I think, she mentioned the Soares case, which is actually overruled on other grounds, but it's a really good case to read because it does a very nice job of detailing all the different areas that a defendant should be able to understand and make decisions in order for that to be a finding that a defendant is fit. And I think it's a really nice sort of summary of all the types of questions that, frankly, a defendant probably should be able to answer in order for somebody to say, yes, you are fit to proceed. So we'll see how that plays out. I don't know. Okay. So I told you we talk about the ABA criminal justice mental health standards a little bit. And again, like I said, these are certainly not binding. I think they're aspirational for us. But standard 7-1.2 talks about responding to persons with mental disorders in the criminal justice system. And the ABA standard says that we must recognize special needs, ensure accountability, respect civil liberties and public safety. We are supposed to have services available in correctional and mental health facilities to evaluate and treat during incarceration and plan for treatment upon release, and develop valid and reliable screening, assessment, diversion, and intervention strategies so that we can divert folks from arrest and criminal prosecution. We can have special court dockets, and we need to be consulting with mental health professionals. And so, I think that the top one is recognizing the special needs and ensuring accountability and respecting civil liberties and public safety. I think, like I said, in the beginning, we're all here because we care, and we all have our little lanes that we stay in. I think at the end of the day, though, we all care about all of these things. And even if you're a defense attorney, you care about public safety. And even if you're a prosecutor, you care about civil liberties. Because at the end of the day, and I'll talk about this a little bit down the road when it comes to sort of public perception of the 704 process, and I think our ethical obligations there is we all want to make sure that this process stays alive and well and is as robust as possible, so that we can provide individuals who end up in the clutches of the criminal justice system, who have legitimate mental disease, defects, or disorders, that we can provide them with what they need, and that we don't end up like a situation that they had in Florida, where 80% of the people in, Miami-Dade, I think it was 80% of the people in their jail basically had like severe mental illness. I mean, the jail was like the largest mental hospital in the state. And so, I think it's important that we not abuse, but also not underutilize the process, so that it continues to be something that the public supports, the legislators support, and that all of us in this room support. Having services available obviously is challenging. I think in our correctional institutions, that's definitely lacking. And we're not the only one. I mean, we're in good company. Like I mentioned earlier, that when I went to this national conference, in one of the states, and I forget which one it was, they don't even bother with fitness restoration. They basically figure out if the person is dangerous or not. And if they're not dangerous, they just like eventually just cut them loose and say, we can't, see you next time. And if they're dangerous, they have other like civil commitment type proceedings that they can divert into, but they don't even bother with restoration. And so, to the extent that we're not really doing fitness restoration in our jails, I don't think we're an outlier in that at all. I'm happy to hear from Dr. Shields, I think, that they're doing fitness restoration in the Hawaii State Hospital, even though it's maybe not consistent. It's great that they're doing it there. So I think we're at least addressing that issue. Develop valid and reliable screening, assessment, diversion, and intervention strategies. We've struggled immensely, right, with diversion, and I'll talk about that a little bit more, because the idea, and I think the ethical obligation to divert appears in 704 407.5. And we right now are struggling. We lost Mr. Rulli on the Hilo side. I think we've had a really hard time finding somebody to run our diversion program over here on the Kona side. We're just sort of limping along. But I do think that it is an ethical obligation of all of us stakeholders in this realm to support and to make happen diversion options for this population. Special court dockets, we have the 704 days. I think we're there with that. And consulting with mental health professionals. I mean, I really like, we have the BIMAC and the CONAMAC meetings, lawyers attend, mental health professionals attend. We have, very open and honest discussions about things, and attorneys, judges, everybody participates. So, I think aspirationally we're doing okay. ABA standard 7-1.4, the role of the attorney representing a defendant with a mental disorder. So it calls for client-centered representation, and here it is, that is interdisciplinary in nature. And so when we talked about competence early on for an attorney representing somebody in a Chapter 704 proceeding, this is where I think you find the idea that it requires more than just knowledge of the law. And if nothing else, the presentations today, I think, have driven home the point that you need to understand the mental health system, what's available, what's out there, what everybody's obligation is. And if you don't know those things, you need to know where to go to get the information. Because there's one thing about, I think, our legal community and our mental health community here is that we are always willing to share information. We're always willing to help. And so if you don't know what you don't know, but if you think you don't know something, ask somebody. work closely with clients to ensure they understand their options. So that goes back to the communication. I think it was 1.4 under our Hawaii professional conduct rules. Explore all mental state questions that might be raised. Again, this goes back to rule 1.1 is you have to be competent. And it might not just involve knowing the law. It might involve more than just being able to say, well, this is the legal procedure. You should be exploring your client's mental state. Seek relevant information from family members and other knowledgeable collateral sources. So this sort of implicates the competence rule 1.1, but also 1.6 confidentiality of information, because like if you're going to go to family members, like what do you tell them, right? Or do you just say, hey, I'm calling, can you tell me anything about so and so? But sometimes even by virtue of the fact that you pick up the phone and call the family member, you might be disclosing something because that family member may not know that your client is in trouble with the law. And you're like, hi, this is Wendy from the public defender's office. I represent so and so. Can you tell me about their mental health history, right? So I think you have to be careful and you have to know how to properly navigate that. And if best case scenario, get the okay from your client. And then, of course, you're in the situation where a family member is going to say, well, what's going on with them? I haven't seen them in a year, right? And so all of these ABA standards, I think, implicate certain ethical obligations that as a defense attorney, you have to be able to navigate. And then finally, counsel your client regarding the pros and cons of specialty or treatment courts. And so here they're talking again, and we've heard about this, about, CR can be open-ended. Certain treatment courts can require you to waive certain rights. For example, probation officer can have you hospitalized for 72 hours, boom, based on the probation officer's order alone. So, there's liberty issues that are implicated. You have frequent court appearances that may not exist in regular court, or if the person is actually acquitted on the merits of the case. And so you have to be, I think, competent and know and be able to advise your client properly about the pros and cons of participating in a Chapter 704 defense and potentially ending up on a 704 calendar. Okay. ABA standards continue to 7.1.5, the role of the judge and the prosecutor in cases involving defendants with mental disorders. And so, I think Corey talked about this, the Pate case, that the court has an obligation to hold hearings if the court believes that there is a fitness issue, even if no party moves for fitness. If the court is up there, and I've had situations where I'm like, I don't think this person is okay, and nobody's making any motions. And so, I think it is an ethical obligation on the part of the judge then to not simply ignore it, but to make their observation known and take appropriate action. And so a prosecutor, so there's an interesting case. Let me see, I have it here. So there's an interesting case. I think it's the Castro case, and somebody I think cited to it earlier in our presentation. But it's a situation where the defense attorney moved for a 704. And I will just read to you what information the defense attorney put on the record. Let's see. Castro has two prior attorneys whom Castro felt were conspiring with the prosecution. During attorney-client interviews, Castro does not listen and or does not comprehend what the attorney discusses with him. During interviews, Castro appears unable to concentrate on what is being said and looks around and comments on what is going on around him. Castro has been fixated on his belief that the events for which he is charged are part of a conspiracy between the Honolulu Police Department, the prosecution, and the witnesses. Castro is extremely impatient with any counseling by his attorney, wants to proceed to trial immediately, and feels that divine guidance will result in him being vindicated. On Sunday, September 21, after a probing inquiry of Castro, defense counsel was informed that Castro suffered severe head injuries about 3 years ago and was under treatment by physicians for head injuries. Castro admitted to a history of chronic use of methamphetamine. Defense counsel believes Castro is unable to work with counsel in preparation for trial because of a mental instability or brain damage. Okay, so that's what the defense attorney put on the record, asking the court, over his client's objection, mind you, to order a mental examination. And so prosecutor objected and said, the declaration of counsel indicates that the defendant may have suffered some kind of trauma to the head, which possibly resulted in some brain damage. If that's the case, I don't even know if a 1-panel or a 3-panel is going to be appropriate. So that was the prosecutor's response. And so when I read that, I thought to myself, okay, what ethically, as a prosecutor, do you have any ethical obligation to object if you don't believe it's appropriate? Or is it unethical for you to object after a defense attorney has made that type of disclosure? And I think, to make matters worse, based on the prosecutor's objection, the court did a little colloquy with the defendant. And it's very funny, because the way it's transcribed in the case, it's transcribed like literally the way the defendant was speaking in like pidgin English, and it's in the case. It's kind of a funny read. But at the end of the colloquy, the court actually denied the defense counsel's motion. And I mean, the reason why I know about it is because, of course, it went up on appeal, and the ICA said, nah, you can't do that. But the other ethical consideration that I think sort of comes out of this case is, did the prosecutor actually lead the court into error by objecting, right? Because probably if the prosecutor had said, no objection, Your Honor, the court would have just gone ahead and ordered the exam. But in light of the prosecutor's objection, and then the defendant during the colloquy with the court objected as well, the court denied the motion. But I think it raises some ethical issues around, the prosecutor objecting. What's the basis for your objection? You don't have any information about what's going on with the defendant. And so, number one, implicating, again, maybe candor to the tribunal, Rule 3.3 that we have. Or is it ethical for the prosecutor to maybe lead the court into error in this case? So those are just some things that sort of stood out to me in the Castro case. Okay, and so the role of the judge and the prosecutor in cases involving defendants with mental disorders: consider treatment alternatives to incarceration, and that is actually specifically in 704 407.5, and I'll show you that in a moment. Facilitate meetings among service providers and other stakeholders. So I think, our CONAMAC, our BIMAC meetings, I think we are meeting this sort of aspirational ethical obligation to have this discourse. Create diversion programs or specialty courts. Again, I think that's something that we are all working on. Consider mental disorder and treatment referral when making charging or dispositional decisions. And so again, I think that's something that the ABA standards recommend prosecutors look at. And again, this sort of implicates the situation where we sometimes say, well, we just need to get them into the criminal justice system to get them help, right? That's all we want, to get them help. And I don't know, I'm not a prosecutor, but I just flag this because I think it is something that the prosecution should consider, whether that's actually the right decision or not. And the court obviously has to consider mental disorders and treatment referrals when making dispositional decisions. And consider and rely on evidence-based practices, including risk assessments and treatment needs. So I honestly have to say, I don't know much about risk assessments in the area of mental health. I mean, we see them sometimes in the 704 reports, but my area of knowledge about the type of risk assessment tools that are being used is fairly limited. And obviously, treatment needs were reliant on communication from our forensic team, the examiners, and other stakeholders. Okay. So ethical considerations for the court and counsel in chapter 704. So, honestly, every time I read this chapter, I read stuff that I never knew before. And I don't know, I tell myself it's because the chapter keeps getting amended. It's not because I don't read it. But anyway, so chapter 704, 407.5, under subsection 1 says, whenever the defendant has filed a notice of intention to rely on the defense of physical or mental disease, etc., or there is reason to believe that the physical or mental disease, disorder, or defect will or has become an issue in the case. So I thought that was interesting because, like, we require motions, and over the years, I've heard from, from judges, and I do it myself now that I'm a judge, and I've heard it from like forensic coordinators over the years, like, well, why what's the basis? There's no basis, right? And I think that arguably 704-407 simply requires the defense attorney to file a notice of intent to rely on the mental defense. And I'm not sure that it really requires much more than that. I think everybody here works together, and we tend to communicate well. And so we tend to be, I think helpful by disclosing at least a minimal basis, like, oh, my client has a mental health diagnosis or what have you. But I don't know the answer to this, but it seems to me that the filing of a notice under the statute is sufficient. And I think maybe the reason why it is because, like I mentioned earlier, we have that rule 3.3, candor to the tribunal. And so, if you file a notice of intent to rely on a mental defense and you have no basis for it, are you being misleading to the court? I mean, that's something you got to ask yourself. I don't know, right? So that's for you defense attorneys now to figure out. Okay. And then it goes on to say, whenever there is reason to believe that the physical or mental disease, disorder, or defect of the defendant will or has become an issue in the case, the court may enter into an agreement with the parties at any stage of the proceeding to divert the case into an evaluation of the defendant, treatment of the defendant, including residential or rehabilitation treatment, or any other course or procedure, including diversion into specialized courts. And so the reason why I flag this is because it's interesting that it seems to encourage counsel and the court to get together and try to figure out something other than our sort of standard, keep it in the judicial system type of disposition. And it says that, going on to the subsection 2, for those cases not diverted by an agreement, right? And so the court shall appoint 3 qualified examiners, and then we go down our merry little 704 evaluation process that we've been talking about all day. But I think this is interesting because it seems that the default is for the court and the parties to enter into an agreement to do something different than the regular 704 process, if there is reason to believe that mental health is an issue in the case. That paragraph comes before the one that says for cases that are not diverted. And so I think that's interesting, because we always sort of immediately go to the 704 when we have clients who and defendants in the courtroom who may suffer from mental illness. But it seems like your ethical obligation under the statute is to at least talk about it and figure out if we really need to go that route or if we can do something different, right? And that's just my interpretation, my read. You're free to disagree with me, but I thought that was kind of interesting. Okay, additional ethical considerations. So it's interesting because when I kind of Googled this topic, mental health, mental defense, and things like that, very sort of consistent sort of things come up. And so as far as the public's perception. And so I think what's important is that we balance the fairness to the defendant with the safety of society and ensure that defense is neither overused or misapplied. And so I think if you read a lot of sort of the non-lawyer publications on the topic of the mental defense, most of them advocate that, treat mental health claims skeptically yet compassionately. But the public perception is that many view the mental health defense skeptically and think defendants manipulate the system to evade responsibility, kind of like the legal loophole thing. And I think that does sort of play into our ethical considerations because both lawyers and courts are responsible for a large part for this public perception. And like I said earlier on, if we want to make sure that we maintain a robust Chapter 704 and mental health proceedings in the state and have the support from the people who can actually make it happen for us. I think, Corey mentioned, why hasn't the legislature done anything about the juvenile fitness and capacity situation? I mean, we need help from the legislature for that. And the legislature, they listen to their constituents, and those constituents are the public perception. And so even though it's not your primary responsibility, but as unfortunately a cog in this system, I think it's something to keep in mind when you have to navigate the 704 process and make decisions about how you're going to treat individuals suffering from mental illness in the criminal justice system. You read a lot about maintaining the equilibrium to preserve the public trust and fairness in legal proceedings and prevent misuse of the insanity defense while guaranteeing access for genuine cases. So again, this is kind of making sure that your decisions regarding moving for 704, your decisions regarding whether the reports are going to be sealed or not, your decisions about what to disclose on the record, your decision about whether you're going to run the defense or not. These are all, I think, ethical and professional considerations that play into sort of the public perception of the mental health defense and should be things that should be considered. Judgment should reflect an accurate assessment of criminal responsibility while respecting the dignity of individuals with mental health issues, and ensure that genuine mental illness is properly diagnosed and documented. So these are some of the sort of the suggestions that I got out of just reading sort of general literature regarding the public's perception of the mental health defense and the processes there around. Okay, further, ethics and policy considerations. And so how we apply Chapter 704 can inform an impact on policy debates and reforms. And so for an example of that is, and this was also a case that was mentioned earlier, State versus Abion, I think you pronounce it. Should the insanity defense be restricted or expanded based on evolving psychiatric knowledge, right? I mean, this is an ethical policy type consideration, and this Abion case deals with the issue of settled insanity from self-induced intoxication. And so, up until that point, courts were very reluctant to entertain the idea that somebody could use drugs so much over the course of their life that they basically, even when they're off of drugs, still present with a serious mental illness or at least symptoms thereof. And that was the issue that was raised in the Abion case. Now, it would be interesting to know and to find out if there was any room in the future for that to maybe be specifically included as a defense, right? And I think that when we apply the 704 chapter in our criminal proceedings, we do tend to impact on what types of policy reforms and what types of policy debates occur around this issue. And we all have, I think, a responsibility to make sure that we do not misuse the process and also advocate for the process in the appropriate cases. And so again, how do we ensure the fair treatment of defendants claiming mental incapacity without compromising public safety? And what is the role of forensic experts in shaping legal standards? And these are all just sort of ethical considerations, policy considerations, I think, that play into the 704 process and how we actually apply it, how you use it as an attorney and as a court, how you handle the dispositions, and as a prosecutor, how you decide to charge cases. Just some things to consider. So like I explained earlier, just do you need your client's consent to move for a 704 exam, and consider, Rule 1.2 and the scope of representation and allocation of authority between client and lawyer. I think there's two separate rules that speak to this. I think if it's penal responsibility, you have pretty clear permission to do so, because it specifically talks, that Rule 1.6, I think, confidentiality talks about being able to reveal confidential information necessary to a defense. And then I think Rule 1.14, client under disability, that gives you the authority to move for a fitness exam, even over your client's objection. So that is sort of the allocation of authority there. But again, you can't run a penal responsibility defense unless you have your client's consent, right? Is it ethical? And I've talked about this too, for the other side to object to a motion for a 704 exam. That's the Castro example. I don't know the answer to that. I just raise it because I thought the outcome of that case was interesting. And then consider Rule 1.4 communication. Do you have conversations with your clients about things? And it was discussed earlier too, sealing reports, Silbeat versus Miley. It's not at all a foregone conclusion that reports are going to be sealed. And so as Leslie mentioned, I do accept oral motions to seal, and generally I grant them. But I will say this, that in a high profile case, I may say no, or I may say, okay, I'm going to redact the report. And so I think those are all things that you need to be talking to your client about, because it's not necessarily guaranteed that very confidential and personal information is going to be out there in public view, because we all know what these reports, doctors' reports say. They include a lot of stuff that if it was me, I wouldn't want it out there, right? And so it needs to really have a good conversation with your client, especially in high profile cases. I think that there needs to be a discussion between attorney and client about the consequences of being on conditional release, right? Unclear duration, you can't it's not subject to interstate compact. So if you have somebody on conditional release and they want to go to another state, it's not covered by the interstate compact. And so that's can be a complicating factor. Privacy rights. Are you giving up certain privacy rights by being on conditional release? There's going to be reports written about you and information about you is being shared with other people. Sex offender registration. So an acquittal for a mental disease, defect, or disorder and placement on CR does not save you from having to register as a sex offender if it's a sex offense. And so, that would be a good reason why a client or the defendant may say, I don't want to do CR. I'll go to trial because I could end up being a sex offender or on the sex offender registry for the rest of my life, even if I'm acquitted for mental disease, defect, or disorder. Second Amendment issues, right? Firearms and things like that. You run a mental defense, or you allow certain information to become public. It could affect your clients, the defendant's ability to own, register firearms. And then this was an interesting one. As I was kind of reading through some stuff on the internet, I came across the Nick Reiner case. And it was kind of just an interesting sort of collateral consequence of a mental health situation. So Nick Reiner, obviously, he's the one who's accused of shooting his two parents, right? And the attorneys were trying to get paid, and they wanted access to his trust funds. But prior to the alleged homicide that he allegedly committed, he had been determined to have a substance abuse problem, and he had gone to treatment. And so there had been a determination made by the trustee of his trust that he was not competent to receive proceeds from his trust. And so they hadn't been giving him any money. And so the article talked a little bit about the current defense attorneys, or they were speculating that the current defense attorneys were somewhat reluctant to run a mental health defense for him because that could further complicate his ability to get money out of the trust, and things of that nature. So I thought that was a sort of an interesting collateral consequence of, for example, a mental health defense. And not that, we on a daily basis have clients with massive trust funds, but I think it illustrates that, again, going back to that Rule 1.1, the competence issue, that as an attorney, navigating this area, there are a lot of collateral consequences. There can be a lot of unintended consequences. And your ethical obligation as a lawyer is to be able to explain those to your client as best as you can. And so, with that, I am done with my section. I think I'm 15 minutes ahead of schedule. And I don't know, I'm sure I've been clear as mud and nobody has any questions, but if you do, yes, in the back.
How do I tell my client has mental health issues versus just being difficult? How do I come to that conclusion? Do you have guidance on it?
Well, hard to tell sometimes. You know, I mean, it's sometimes it's just kind of a gut call. But I think what it does require is for the attorney to spend significant time with their client, because as Dr. Bauer Smith mentioned, like she can be talking to somebody for 30 minutes and the individual can seem fine and maybe just difficult. And then at the 30-minute mark, they start talking about being employed by the CIA and having, like, you know, FBI credentials or whatever. So I don't really know that I have a good answer for you, other than that oftentimes it's a gut reaction. If the client authorizes you to talk to family members, that can be a good source of information. But again, you have to sort of navigate that carefully with the confidentiality and communication ethical obligations. I've been sort of out of the trenches of having to make that call for the last 8 years. So I'm happy if any of the other criminal defense attorneys in the room who have dealt with that issue want to speak to that topic. I know Leslie, Rachel.
I was gonna say, come hang out with public defenders for like a week. We'll show you all you need to know.
Yeah. No, you know, I think the problem is that a lot of times it's less so much difficult versus mentally ill, or is it under the influence of like substances and mentally ill, right? And so I think the harder problem is the defendant like actively like psychotic, or is the person just coming down or high on meth, right? And that's the more difficult call. And you know, sometimes it can take 30 days for you to get a good read on the individual, and the decisions regarding fitness have to be made fairly quickly, usually. And so I think that's the more difficult problem that I see, is determining, is it substance abuse, or is it mental illness, or is it settled insanity, as the Abion case talks about, right? And I will tell you this, that we've been talking a lot about mental illness diagnoses, but Chapter 704 also covers physical disease, defect, or disorder. And I will say that, just to leave you with my little war story, when I was at the public defender's office, I had a client who was accused of attempted murder against like his sister and others in his household, like people who you would not think would be likely targets of his violence. It was reported that he had been up for days. He had lost a tremendous amount of weight. And he then went after various family members and violently assaulted them and almost killed them. And when I talked to my client, he swore up and down he was not on meth. He'd never touched any meth. And everybody was like, this guy is high as a kite. He's spun up. He hasn't slept in days. He's dropped 50 pounds in like 2 weeks. And everybody said meth, meth, meth. Now, to the prosecutor's credit, I will say, this was interesting for this reason as well, is that it was actually the prosecutor who suggested, why don't we get a physical exam? And so we actually agreed on stipulating to have a doctor examine my client. And what turned out to be the issue was that he was suffering from what we call a thyroid storm. And and I guess what I learned in the course of that is that the brain is probably the organ that is most affected by imbalances in your thyroid. And he had like a super hyperactive thyroid, and which had caused him not to be able to sleep. He had lost all sorts of weight, and essentially he was temporarily insane. And I have to admit that, you know, were it not for the fact that I had a good working relationship with the prosecutor, and that she was the one who actually said, why don't we look at this? I don't know that I would have believed that my client wasn't high as a kite on meth, and you know what I mean? So it's a hard call to make, and physical conditions can have a tremendous impact on somebody's mental state as well. So that's another thing, right? You can't overlook that as well. And it's a completely viable cause for somebody to act in a manner that we would say, nah, it's drug induced, right? So anyway, he ended up on CR and is doing great now, but.
Judge, we actually, in the new orders, we now have, one of the new orders is
Oh.
a motion for physical.
Oh, okay.
Yeah.
Okay, so yeah, Corey says one of the new orders actually permits a physical exam, you know, as well, because we have that, you know, we have people who have like, you know, I don't know, terminal cancer or you know, heart problems, or a combination of various things, and they physically can't even like walk more than 5 feet, can't get out of bed. I mean, somebody could conceivably be unfit to proceed because of a physical condition, right? So anyway, any other questions? Dr. Shields?
On 704, 407.5, that second paragraph you're talking about diverting, if there is, mental health issues going on, what would be the mechanisms to make that happen? Would that be you put someone on supervised release and then manipulate, or how would you make that happen?
Okay. So if we were going to go with the second paragraph on 704, 4.7, 407.5, prior to the 704 process, considering some kind of diversion out of the criminal justice system, what would be the process? Honestly, I mean, it could be a deferred prosecution where the person maybe completes certain treatment and then the case is dismissed. It could be SR, right, and see if they comply, and then if they comply, case gets dismissed. It could be, I don't know, get the person set up with Care Y, wraparound services, they're really engaged, and dismiss without prejudice and see how the person does. I mean, on a felony, you have, 3 years for most felonies to recharge it if the person flames out. I mean, so I think they're creative ways to deal with it. It's just, I have to say, nobody's ever come up to me and said, hey, judge, I think there's a mental health issue here. We want to try to divert this person out of the criminal justice system. And probably because we just don't really have a good process for that or resources dedicated to that. But I think it's something we could look at for sure. And especially at the district court level, right? The lower level cases, right? Why not just, I don't know, get the person set up with everything and then dismiss or defer or what have you. So any other questions? Nanette?
Is third circuit considering any specialty court like mental health court instead of mental health calendar?
It would be nice. We'd probably need to, it would be great. I think from the judiciary's perspective, our next step is going to be try to get a women's court in Hilo. And then maybe after that, but it's basically a money and a resource issue. And the ledge would really need to allocate some money. Well, we'd have to go to the ledge and propose it, and then the ledge would have to be willing to allocate money. The good thing is that Oahu already does it, right? And so, and they, I assume, are successful. And so it's easy to piggyback on them for requests, but I think that that request has not yet been made. So, any other questions? Okay, thank you all very much.
So next on the agenda, we set aside time for general questions and answers. So I'm going to ask all the speakers that spoke today that are still here to come up to the front, please. Oh, yeah. Hello.
Hi.
And this is also a photo op, by the way.
Oh. Any general questions? Pick our brain for free for 15 minutes if you want to. No? We've exhausted everybody. Sarah?
You mentioned that you went to the RA's conference.
Yeah.
Tennessee. What were some of the best kind of remedies that you heard about from different states, different courts?
So the question is addressed to Judge DeWeese, and the question is, what are some of the best remedies that you heard at the recent conference that you attended?
Best remedies. Well, I mean, I think that the conference itself is a treatment court conference, right? And so, and really advocates for a non-adversarial approach, as well as a holistic approach. And I think as I mentioned that under, when I was talking about competence and needing to have an interdisciplinary view of your client situation as a defense attorney, I think coming out of the All Rise conference, it was really clear that courts need to have sort of an interdisciplinary view of the cases that come before them, and that we call certain courts treatment courts, but the idea that treatment courts are based on should apply to any court and to any person coming through any courtroom. And it shouldn't just be limited to a treatment court, but it's really a way to address most individuals who come through the criminal justice system. Specific remedies are just things like, you know, like we all know, like having the services available, understanding that you get more with incentives than with sanctions. And so maybe, you know, that our whole idea of punishing people, but not incentivizing people, right? All we do is punish. We rarely incentivize. So things like that. And Rachel was there too, so she may have some further.
Yeah, I mean, I think one of the big takeaways was that, yeah, as Judge mentioned, like having a more holistic approach to dealing with it. Mental health and substance abuse are public health issues. They're not public, I mean, they create public safety concerns, but we need to treat it like a public health issue and not by criminalizing it and punishing people that have legitimate substance abuse disorders or mental health disorders. And I think what All Rise is doing across the country and mental health treatment courts, substance abuse treatment courts is trying to look at, again, a wraparound services and trying to get all stakeholders to look at the individual as a whole person and provide individualized care and treatment to that person depending on what their particular issues are. A lot of our clients are dual diagnosis, so they may have substance abuse, but also have ongoing persistent serious mental health. Specifically for women in our treatment courts, they tend to have a lot of diagnoses in addition to substance abuse. And so trying to be more mindful, again, from a public health perspective on treating this and not just locking people up, because that does not solve anything.
Anybody else? I see a hand. Yes.
Paula.
I just have a comment. I think it makes them well to maybe put together some kind of committee of community agencies to see how that diversion piece could work and what people might be
Working
group.
yeah.
Yeah, no, I think what you mentioned is really important. I think trying to get, I mean, I think we all care about how do we better service this population, and funding is a huge part of it. Resources is another huge part of it. And yeah, I mean, I know I, for one, would be a huge advocate to get on some committee and find a way to tell Grayson or someone from the judiciary to ask for more money for a specialized treatment court that could address people that have mental health issues. So I know I volunteer myself to be on that committee. So.
Are they still doing the county mental health summit annually?
I
I
don't.
don't know.
There used to be, there may still be, I don't know if anybody in here knows, but annually, the Hawaii County used to hold a mental health summit. And I know Ann and I attended a while back, a number of years ago. But that was a great resource because it brought all of the stakeholders together. But I haven't heard anything about it recently, so I don't know if it's still happening, but maybe we should look into that, because that some of these resources sometimes already exist, we just don't know about them, or you know, are not connected up with them. So if nobody knows, maybe I'll look into it.
Well, and another thing too, I mean, I think that jail diversion has the framework to provide a lot of these ideas and put them into action, but we just don't have adequate funding for enough positions to actually service the volume of cases that we have. I think each of the jail diversion individuals carry a caseload of like 10 or 15, depending on if it's felonies or misdemeanors or petty misdemeanors. But we have like hundreds of people that would have qualifying cases if we had the resources and capacity to actually supervise them in a diversion model, as opposed to bringing them into the criminal justice system.
Yeah, and I think that's why everyone is trying to be creative with solutions. Like Mr. Woodward in district court, you know, because of the lack of resources here on Hawaii Island specifically, he'll go ahead and exercise his discretion and dismiss cases, especially if somebody has a history. But really big props to Kim Pratt. She's been coming to court and interviewing in custodies, gosh, almost on a daily basis, right? So we get emails from her all the time, and we really appreciate that. And we see, you know, the tide's turning for the better. We just, you know, unfortunately don't have the funding.
We need to clone you by like 5
Yeah.
or 6 more people.
Definitely.
So,
Yes, in the back. The question is whether intake services could get involved in any kind of diversionary program.
So I will say this, I did for the longest time, I was under the belief that intake service center could not assist with individuals entering into substance abuse or mental health counseling as part of a pretrial bail order because they didn't have the contracts, and many people don't have insurance. Like probation has contracted providers that people can get referred to and that financially can get covered and things like that. I was under the impression that intake service center did not have that. Now, I did speak with somebody the other day who informed me that actually, and that individual didn't know if it was a recent change or it was just a well-kept secret, that they actually do have contracts and funding to help people enter into and remain in substance abuse treatment and mental health treatment. And so I was always under the impression that as a judge, it was sort of useless to order people into those types of treatments because it was something that defendants could not accomplish for financial reasons. But I now have learned very recently that that is not the case. And it may be part of the turning tide that Rachel talked about, you know, that the legislator is starting to take a look at that. Also because we've had a lot of interest in bail reform, and it goes sort of hand in hand with the whole bail reform piece, right? To make sure that we can supervise people in the community pre-trial rather than locking everybody up pre-trial. And so it may be a recent change, but I think that I do have a little Post-it stuck on my desk to call Kelsey Makaike at the Intake Service Center to see what our options might be in that regard. So that's a really good question.
And I saw Josh had his hand up.
Oh,
Yes.
So I know it seemed like one of the barriers in Act 87 was the voluntary, the consent, but it also seems like jail diversion requires consent. So I wonder what the reasons are that the consent is more of a barrier in Act 87 and less of a barrier in jail diversion.
Well, I think that consent is still a barrier with jail diversion because it is a voluntary process. A lot of people decline services. I mean, I think in the last like 60 days, we've had a handful of people that clearly meet criteria, would certainly benefit from jail diversion, maybe have been on it before, but they're declining it because it's voluntary. So it is hard when we find someone who's eligible and they just like, no thanks, you know, so. And we see them cycle back in and out and in and out and in and out. And some of them are back in jail and some of them are still out in the community. But I think the consent issue is kind of it is an all around problem, whether it's jail diversion or assisted community treatment or whatever you have, so.
Yeah, and I think that the Act 87 is a much narrower scope because then those people you know are unfit. So they're much less likely to want to engage in services because a lot of times they don't think they need them. Jail diversion is a little bit different. You get a bigger group of people who may be suffering from some degree of mental illness, but they might actually be fit. But they may have substance abuse issues. They may have other issues that are contributing to that kind of behavior. Act 87 is a much narrower scope, so you're not going to get a whole lot of people there and jump on board. What's the alternative? I mean, their cases get dismissed, so you don't have any teeth in them. So they're walking out the door.
I have one final kind of like a soapbox thing about Act 87. So we have this thing called assisted community treatment. I think it is an extremely underutilized resource. The problem is that there needs to be an interested stakeholder to basically ask the court for the court to order assisted community treatment. Finding someone who is willing to do that has really been difficult. I think we as defense attorneys, like, we're not going to ask the court to like forcibly medicate our client or anything like that. The prosecutor's office doesn't necessarily want to take that position either. The attorney general's office can file the paperwork on behalf of an interested party, but they themselves cannot be the interested party. So it really would take like someone in the community, case manager, a doctor, even a family member to basically reach out to the attorney general and say, hey, I have a sister, I have a friend or whatever, and try to advocate on their behalf to get the court to order them to have assisted community treatment. So I think we do have some resources that are just not used at all. In the 4 years I've been with the public defender's office, I have not seen any cases that would be eligible that have actually been referred or been able to utilize those services. And so it is unfortunate that we have the legislation out there to do certain things, but there's no like enforcement mechanism or there's no agency that's in charge of actually like making that happen.
I'd like to just jump in there right there. Actually, Amanda RAPRNX, she's filed, what, 4 of them, 5 of them?
I have one coming.
So she's filed more than in this state than anyone else has. So we're actually utilizing it up at the clinic, but trying to get other providers like Care Hawaii to do it. Each doctors aren't wanting to do it. They're not wanting to go to court, but we are utilizing it more on this in Kona than anywhere else in this state.
Well, that's really heartwarming. So yeah, thank you. And we need more of you then to try to get our clients, you know, on that route, so.
Any other questions or comments? Okay, that includes question and answer.
Yes.